Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's episode, we are entering the next part of the ongoing Hailey Paige beauty fashion lawsuit extravaganza against JLM Couture. When we last left the action, we reviewed the initial complaint, and now we're going to review the next document up from the judge, which is an order to show cause. So one of the things in the complaint was a request for a temporary restraining order and a preliminary injunction. So normally when these things are filed, a couple things can happen. The judge can ignore them. Sometimes the judge grants them automatically in particularly obvious situations where the harm is obvious and irremediable. And then there's the middle ground, which is the order to show cause. So the judge thinks, now there's some validity to this. We do need to have it. So why don't you tell me why I shouldn't grant it? So this is a judge giving the other side an opportunity. Tell me why I shouldn't do this. So let's see what the judge has to say. Let's get started with this. So this is the order to show cause for the preliminary injunction, temporary restraining order. The judge is asking for the Hailey Paige Gutman to respond to the temporary restraining order request. So upon the motion for a temporary restraining order and a preliminary injunction supported by the declaration. So just a brief aside here about the difference between a temporary restraining order, also known as a TRO, and a preliminary injunction. The only real difference is in the timing and the amount of due process that comes. So TROs tend to be very, very early in a case. They can be granted automatically. They're usually granted very fast if they're granted at all. Preliminary injunctions, sometimes it depends on the nature of the case, but sometimes they don't come for a while. So they can be delayed, but it's not unusual for an attorney to ask for both right off the gate. So anyway, by the declaration of Joseph Murphy, working for JLM, the declaration of Brittany No, and the declaration of Sarah Matz, together with the exhibits, the memorandum of law by JLM, and the pleadings herein, good sufficient cause appearing therein, arguments of counsel heard on the 16th. So here the judge is saying, okay, look, I've taken a look at these declarations that have been filed by JLM. I've taken a look at their arguments that have been filed by JLM. We had a hearing, which I don't have the transcript available for that, so we can't review that right now. But we had a hearing on this to hear argument. And after looking at all these things, it looks like I should be granting the temporary restraining order or the preliminary injunction, one of the two. And so I'm now giving you basically a last and final opportunity to tell me why I shouldn't do that if I'm about to make a mistake. All right, so let's read on. So the judge orders that the above named defendant, Hailey Paige Gutman, show cause in a hearing by remote means on January 29th or as soon as thereafter as counsel may be heard, why an order should not issue pursuant to Rule 65, which is the rule that allows for this, as follows. During the pendency of the action, enjoining, which is stopping or halting, the defendant along with her officers, agents, servants, employees, and attorneys, and other persons who are in active concert or participation from taking any action. So basically Hailey Paige and anyone else who knows Hailey Paige and anyone who's acting on her behalf. So all the people that she has control over. So prevent them from doing the following things. From making any changes to any of the social media accounts that were listed in the exhibit, the so-called JLM social media accounts for Hailey Paige. So all those accounts, they'd be prohibited from making changes, including that, but not limited to. So you can't make any changes, but let's tell you specifically the changes you can't make as well. Changing the name of the handles on the account, posting any new content, or deleting or altering any content, from tagging any other post, user, or account, transferring any such account from defendant to any other person except to JLM, or communicating with third parties through those accounts for commercial purposes without the express permission. So basically, you can't use these accounts, you can't post to these accounts, you can't delete or alter these accounts, and you can't communicate to others through these accounts. And if they're JLM's accounts, that would be right, because JLM would obviously be in control of who has the right to use his accounts. And if they want Hailey Paige to use their accounts, it's their property. So that would be a reasonable thing for JLM to have the authority to manage. From using or taking any action to gain control over any of the social media accounts without express permission of the Chief Executive Officer, Joseph Murphy. So again, if JLM, for whatever reason, wants to modify this order unilaterally to allow Hailey Paige, or anyone else for that matter, to create content on their account, it is their account, or so it would seem. So if you get permission from the chief executive officer, then knock yourselves out. It's their account. They can do with it as they like. From taking any action that breaches the employment agreement with defendant, together with any amendments and extensions thereto, specifically but not including to enjoining defendant from using Hailey Paige, Hailey Paige Gutman, Hailey Gutman, Hailey Paige, or any derivative thereof, including Miss Hailey Paige, which is the designer name, trademarks and designer names, including but not limited to the trademarks identified on Exhibit 2, or any confusingly similar marks or names in trade or commerce without express written permission of the chief executive officer. So here I want to take a brief aside and just note the difference also in practice between a preliminary injunction, TRO, and a final judgment. So a TRO, or a preliminary injunction, is primarily used to freeze things in place, to make sure that everything, and also to remedy any very immediate harm. So if something has happened extremely recently, we can sometimes undo that with a TRO or a preliminary injunction. But it's mostly meant to freeze everything in place. So just because the judge is saying here in a TRO or a preliminary injunction, or the judge is alluding to the possibility that in the future they might decide to say these accounts belong to JLM, it doesn't necessarily mean the final order will go this far. So the judge is here saying, I'm looking to put a stop from you using any of these names in any social media context for the pendency of this thing. Now, when the issue is ultimately decided and the rights between the parties and the property rights are a little bit more understood, then the judge will give a final order that will be a little bit more nuanced. So you wouldn't necessarily expect this broad recitation to survive throughout the end. It could, but it's also reasonable to expect, and I think even likely to expect, that you would see some modification for this, because when I reviewed the contract language, it didn't seem to allow JLM to have quite the extensive rights that they would be asking for in this TRO. But freezing it in place, because that's how the names have been used, makes sense, even if that's not going to be the ultimate remedy in the future. So just a slight note there of how that can differ and how we might expect it to differ going forward. Using any designer names, trademarks, or confusingly similar term to endorse, advertise, or promote the products or services of Hailey Paige, that would be herself, or others, directly or indirectly, including on social media. So basically, you can't use JLM's name, and you can't use any of these trade names to promote any products or promote or advertise or endorse. So you can't use any of the names that belong to them during the period of this lawsuit, because at the moment it looks like it's more JLM's property. Again, as this case develops, you might expect that to be modified, and you might expect a final order to be a little bit more nuanced on what JLM and what Hailey Paige can do. But for the moment, this basically freezes everything in place. From using or attempting to use third-party names, the designer names, trademarks, or any confusingly similar terms without permission. Same kind of idea. You can't use it, and you can't authorize others to use it. And also ordering that within 24 hours of the order and during the pendency of the action, defendants shall deliver to JLM attorneys the login credentials, including current username and password for the main Instagram account, the Pinterest account, and the TikTok account with the handle Miss Hailey Paige, and take any action necessary to enable JLM to regain access and control of said accounts, including linking the accounts to one of JLM's email addresses or phone numbers or any other social media accounts. So we need to give you the name and password, and also anything else you might need to do. So if there's two-factor authentication, you need to turn that off. You need to do whatever is necessary to help transfer the order. So that's basically what that's saying there. Is therefore order having sufficient reason pending the hearing pursuant to the rules. Okay, so the judge now is going to say what we're going to do in the interim. So I'm looking to put in place an order. Tell me why I shouldn't do it. But in the interim, before you have a chance, I'm convinced enough to require this. So this is also probably differentiating between the temporary restraining order and the preliminary injunction, right? So I'm about to issue a temporary restraining order in practice, and this might manifest into a preliminary injunction, which of course can be changed during the course of a case. It can be modified as if it needs to be. But the judge is saying, I have enough to rule this much. Okay, great. So what can we rule on this far? The defendant, along with their agents, officers, servants, employees, and attorneys, and other persons, are stopped from taking any of the following actions: from making a change to any of JLM's Hailey Paige social media accounts, including but not limited to the change of name of handle, posting new content, or altering, from tagging, transferring to any other person except JLM, or communicating with third party, from utilizing or taking action to gain control over any of JLM's Hailey Paige accounts without express permission, from taking any action that breaches the employment agreement by using the designer name, trademark, or any confusingly similar names, from using a designer name, trademark, or confusingly similar term to endorse, advertise, or promote products, and from using or authorizing third parties to do this. So if those two things look very, very, very similar to you, congratulations. Yes, those two things look very, very similar. So in the interim, I am so convinced that I'm going to be doing this, which the order to show cause, incidentally, was kind of a big clue. Because you don't get an order to show cause unless the judge is basically saying, I am going to do this, tell me why I don't. So the order to show cause is a pretty big clue. So the judge is saying, I want you to give me a reason why I shouldn't do this. But in the interim, until you do, I am doing this. So I obviously can change my mind. I'm the judge. So if you tell me a good reason why I shouldn't, I can always undo this. But I've looked at the attachments. I've looked at the complaint. I've looked at the declarations. We had a hearing. Seems like they're in the right. So, and unless you can tell me otherwise, I'm going to issue a preliminary injunction. And at this moment, right this second, I'm issuing a temporary restraining order until you can convince me. So again, that's basically freezing everything in place is the point of that exercise. And then ordering them within 24 hours to transfer all the accounts. And then also ordering a security bond in the amount of $200,000, which is a lot of money, incidentally, to be posted by the plaintiffs. So the security bond is meant as a mechanism to make sure that there's compliance with the court. And the JLM is the plaintiff in this case. So this is basically leverage, or the judge is calculating out, if I'm wrong, how wrong am I going to wind up being? What is the likely damages that are going to mature from this? Because I'm telling Hailey Paige to transfer all these assets and transfer all these names and prevent from using these things to JLM. So JLM, I could just rely on their good word, but let's suppose I'm wrong. What do I do about it? Well, there's probably been some damage. Well, how much is the damage? Well, the judge is calculating basically an upper bound of the damage of $200,000. So the judge here is saying, look, I'm issuing this order to transfer these properties. I'm pretty sure I'm in the right, but in the event that I'm wrong, or in the event that I have to undo all this, and there's also JLM asking for asking for it, right? So JLM has asked for all these things. So it's like, I'll give you what you want for the moment, but if it turns out you're wrong, then I could not only order the return of the assets, but I'm ordering you to put up a bond up front. So I'm ordering you to deposit $200,000 with the court. So in the event that I have to transfer the property back, I can just be like, ooh, here's a big pile of money, take X amount of dollars in compensation for the loss. So because it would be a deprivation of property, right? So it would be basically a taking. And the judge is saying, well, if it winds up I'm wrong, I have to compensate you for the taking. So $200,000 sounds like the upper limit for that. So JLM put $200,000 up just in case I have to undo this. So not unusual, not expected by any means. You see a lot of TROs, a lot of preliminary injunctions without a bond, but there's nothing wrong with it either. So it's completely not unusual in that respect. The judge also orders a personal service of this order in the plaintiff's moving paper upon the defendant. So assuming the defendant didn't already get it, we're going to put a burden on JLM to make sure that Hailey Paige gets it. So send her a copy. That any answering papers with an email copy to this email address, which looks like an attorney's email address, filed with the court on or before 4 p.m. on the 12th of January. Plaintiff's reply counsel with copy be submitted by 4 p.m. on the 22nd of January. So just basically saying, when are various papers due in this case? Courtesy copies shall be provided for chambers via email address specified in the court's case. So in addition to filing on the in the internal system, we also want you to mail them separately to our email address to give us a courtesy copy. Fine. All direct testimony shall be in the form of an affidavit filed with the party's principal submission. So if you need to provide new testimony on the order to show cause, fine, but you have to do it in the form of an affidavit. It has to be sworn to. Any live testimony at the preliminary injunction hearing will be limited to cross-examination. So you can't have someone testify live. If you're going to testify, it can only be in writing. And obviously, you can't do cross-examination writing. That doesn't even really make sense. So if you're going to provide testimony, it has to be in writing. If there's going to be any live, it'll be in the form of cross-examination. So submit it in writing or lose it. The parties are directed to meet and confer, and by 12 o'clock noon on January the 27th, file with the court a consolidated and bookmarked, to indicate exhibit numbers, PDF, containing all the exhibits relied on for the hearing. So please provide this in a PDF with tabs, basically, so I can find every exhibit that you're referenced to, and please cross-reference it so I can, file easily where it's going from. And a joint submission identifying the witnesses to be presented for cross-examination. The parties agreed protocol for presentation of testimony remotely and time allocated for each witness and time allocated. And these are all, of course, suggestions, because the judge is ultimately in charge of the court. So the judge is saying, okay, you guys need to talk amongst yourselves, and you guys need to agree what people need to be cross-examined, how you propose to do that over Zoom, and what kind of time limits will be proposed. And the judge can take a look at all that and be like, it's real interesting and all that both sides agree to that, but here's what we're doing now, because, it's good to be the judge. So that's basically what's happening there. And then there's an exhibit just showing all the accounts that are being transferred in this. So we can show all the accounts that are subject to this, so everyone is clear what's going on. So we have here's all the JLM accounts we're talking about. So Hailey Paige, Miss Hailey Paige on Instagram, Hailey Paige on Facebook, Hailey Paige Bridal Facebook, Pinterest Hailey Paige JLM. Hailey Paige JLM is kind of suggestive it's JLM's property, isn't it, though? Pinterest, Miss Hailey Paige. YouTube, Miss Hailey Paige. Hailey Paige JLM on Twitter. Blush by Hailey Paige on Instagram. Blush by Hailey Paige on Facebook. Blush by HP, Pinterest, and Twitter. Hailey Paige Occasions on Facebook. Jim H Occasions. Not sure who or what Jim H is, but okay. Twitter. La Petite Hailey Paige on Instagram and Facebook. Holy Matrimoji Cute on Instagram and Facebook, and Miss Hailey Paige on TikTok. And then we have this exhibit which shows some additional accounts that have to be provided, additional trademarks that are relevant to the case. So we got all the various trademarks and all their various registration numbers, just to show you the various trademarks that are in there. So there's no ambiguity about what the court order extends to and what it doesn't. So yeah, this is not an order to show cause is a relatively rare thing in cases, in the grand scheme. It's not unexpected or atypical. It's just if you were like counting all the cases that exist, how many cases have an order to show cause and how many don't. The order to show cause is relatively rare. The attorneys ask for preliminary injunctions and temporary restraining orders all the time. And most of the time, they're kind of crap. So most of the time, the judge ignores them. But every once in a while, you have one that's not crap. And JLM did submit a fair amount of material to show why it wasn't crap. They provide the employment agreement, which seems to speak to this. The employment agreement, at least in part, seems to extend the trademark to some of these names, perhaps not absolutely, but in some limited context at least. We discussed that last time, how the nature of the contract seems, at least for the trademarks, to only extend to bridal gowns and bridal adjacent things. So presumably clothes that would not be bridal would not be covered. But at least for the moment, we can freeze all that in place and give it to JLM. But, there was a lot, and there was the testimony of the parties that showed how these people operated, what the role of Hailey Paige was in the company, how she operated with the account, how it was created by JLM, the terms under which it was created, how it was handled, and so forth and so on. So the judge's like, yeah, you have enough information here. That seems like you have a likelihood of success on the merits. You have an irreparable injury. It's not that burdensome to Hailey Paige. on balance, and it's in the public interest. So yeah, it's not an atypical finding, something that you would expect based on the amount of information that's here. So good job by JLM's attorneys to get the judge to look at this and consider this. I think a lot of judges are jaded on these kinds of things because they see so much that are crap. But good job on the attorneys and good job on the judge in paying attention. And it looks about right, all things considered. So that's about all I have for this video right now. We will certainly have more Hailey Paige content in the future. If you're enjoying this video, please remember to give it a like. If you're not already subscribed, please remember to subscribe. And did you know, for a mere 99 cents a month, you too can become an uncivilian? It's true. Click to the links, click to the join button to help support the channel. Until next time, my friends, cheers and goodbye.